Abortion is a life and death decision not to be taken lightly. In every case, the welfare of the mother, her health, and the fetus must be balanced. When wholesale law is enacted, the consequences can be severe. Yet, the abortion bans enacted in about half the states since the Supreme Court overturned Roe v. Wade in June do not prohibit abortion entirely. Instead, most make exceptions in certain circumstances, commonly to protect the health or life of the patient or in the case of rape or incest. And as conservative state lawmakers prepare to take up new restrictions on abortion in upcoming legislative sessions, exceptions will be at the heart of the debate. But in the months since the court's decision, very few exceptions to these new abortion bans have been granted, a New York Times review of available state data and interviews with dozens of physicians, advocates, and lawmakers revealed. Instead, those with means travel to states where abortion is still broadly legal or are obtaining abortion pills at home because the requirements to qualify for exceptions are too steep. Doctors and hospitals are turning away patients, saying that ambiguous laws and the threat of criminal penalties make them unwilling to test the rules. Here are 3 examples from the New York Times. Last summer, a Mississippi woman sought an abortion after, she said, a friend had raped her. Her state prohibits most abortions but allows them for rape victims. Yet she could not find a doctor to provide one. In September, an Indiana woman learned that a fetal defect meant her baby would die shortly after birth, if not sooner. Her state's abortion ban included an exception for such cases, but she was referred to Illinois or Michigan. An Ohio woman carrying triplets faced a high risk of dangerous complications, including delivering too early. So when she tried to get an abortion in September through Ohio's exception for patients with a medical need, she was turned away.